So I have today Brian Ward and Jennifer Roberts. Jennifer is an attorney in California, and Brian is a biomedical researcher who is very involved in the legalities of the pandemic. And Brian, you caught my eye yesterday because I saw a very distressing tweet concerning my favorite hospital, Houston Methodist. I believe that's what you were tweeting about. And another roadblock, Goliath wins once again. So, can you tell us what happened?
Yes, but before we can get into Houston, we must explain what happened prior to that case involving Shriners Hospital in Galveston, Texas, because that also went before the Supreme Court. And so it's just a legal technicality that we must understand up front. And both cases argued the same set of facts. That was the hospital entered into a contractual agreement with the federal government to never mandate any individual to use an unlicensed medical treatment that is funded or authorized by the federal government. That's called a federal-wide assurance agreement, and it comes back result from the Tuskegee experiment, where the federal government engaged in medical research abuses against African American males. So in 1974, Congress passed the National Research Act. And without getting into the legal weeds here, it promulgated 42 USC 289, which basically means that the executive branch is under a ministerial obligation, which means they don't have any authority to deviate or not comply with that standard, to protect the rights of the American people when they're involved in federally funded unlicensed treatments. And that right for the last 40 or 50 years has been known as legally effective informed consent. And that's in a phrase, Mary. And yet, HHS has done such a wonderful job in the last 40 years of concealing that right, refusing to effectively educate the American people of that right, that I have not met a single hospital CEO, an executive, or a doctor who knows anything about what's called the federal-wide assurance contract that they're under. And that contract means that they can't force someone to participate, they can't coerce someone to participate, and they most certainly can't punish someone. And that contract is predicated upon them accessing federal funds. So the second contract in place at Shriners was that they agreed on behalf of Texas to administer the COVID-19 unlicensed drugs to the people in the state of Texas under the legally effective informed consent standard. And so on that, we went to court, or the plaintiffs went to court, and they argued these facts. The favorite judge of the Republican Party, Judge Jeffrey Brown, he's the one that stopped Texas from trying to do redistricting, and he tried to stop the dissenting judge in that appellate panel, or that panel, from issuing his dissenting opinion.
Well,
basically, what
real quick, hold on. Jeffrey Brown was involved in our lawsuit against the FDA. And that he issued a motion, he granted them their motion to dismiss. And so we appealed to the Fifth Circuit and won on appeal. But anyway.
Congratulations. That's fantastic.
They are
handing long story short is that he concealed the contracts, he refused to discuss them, and he dismissed a case against federal court procedure rules that he could not do because he would not accept any of the plaintiff's allegations. It went to the Fifth Circuit. The Fifth Circuit panel we knew was being stacked against us. One judge was 90 years old, couldn't even ask a single question, cognitive disability for sure.
Bless his heart.
Yeah, he was basically a auto pen judge.
Which judge was that?
You know, I don't know his name, and I apologize. I know that Judge Carl Stewart was the main guy who wrote the opinion.
Okay.
And so the Fifth Circuit also concealed the federal-wide assurance contract, the rights of the American people involved in these drugs. They would not even discuss how Texas was legally responsible for ensuring no one in the state was subjected to the drugs by contract with the federal, two contracts, by the way, with the federal government. And here's what the Shriners Fifth Circuit panel did. This is where it gets dangerous. They said that Shriners' conduct was not unlawful. Now, they didn't define the conduct. They engaged in what's called deceptive implicature. So at the very beginning of their ruling, they said that Shriners used these unlicensed medical treatments, and that was the contention at stake. So at the very end of the ruling, they said that Shriners' conduct was not unlawful. So they have what's called spatial displacement, and that was by design. And so, long story short, they basically said that Shriner's conduct of subjecting individuals to unlicensed medical treatment was not unlawful. Now, they did that in complete isolation of the alleged facts, that Shriners was under this contract not to do that.
And
So
Brian, remember, everyone needs to hear you. And when you say unlicensed medical treatments, we are specifically talking here about the COVID jabs. This was the jab or job mandate. So every time we hear that, that's what they were not supposed to force their employees, like Dr. Mary, to do.
Well,
And
and
yet this is what the Fifth Circuit was ignoring.
I briefly read part of their opinion, and they mentioned, private versus state actor. Can you discuss that? Like, is that important? And what was the loophole? How did they work their way around this?
Well, the loophole was that they just ignored the plaintiff's allegations. There was no
Because, and you know what, sorry, Brian, sorry to interrupt, but for our audience, let me tell you something. On a motion to dismiss, the standard is that any judge simply must accept as true the plaintiff's allegations. You draft your complaint, you allege whatever you want, and that is the standard at the motion to dismiss stage. The judge must read your allegations and simply accept them as true. They cannot accept the defense version of the facts and then dismiss your case.
So here's what the Fifth
well then
Circuit
so
did.
what right how do they dismiss it then? What are there?
Because as
Here's what
Brian
they
said,
did.
they ignore their role. They literally ignore that requirement. Go ahead, Brian.
Okay.
Well, what they did specifically is they said that, in this case, Houston Methodist and Shriners, they're not state actors for issuing a vaccination requirement. But that's not what was alleged. What was alleged is that the Houston Methodist Hospital entered into a contract with the state of Texas to perform a ministerial obligation owed by Texas to the plaintiffs. So in a Supreme Court case that's well known in what's called state action doctrine. So let me just explain to your viewers for a moment. A private party does not owe 14th Amendment obligations to the public. They only owe 14th Amendment obligations when they're acting on behalf of a government who owes those obligations to the public. So in this case, the state of Texas entered into a contract with HHS, specifically CDC, to administer these investigational drugs to the public on the condition of voluntary basis. And Texas was lawfully obligated under its federal-wide assurance contract and the contract called the CDC COVID-19 Vaccination Program, that they were supposed to obtain the individual's legally effective informed consent, which means they could not be pressured or punished. And so under a Supreme Court case called West v. Atkins, here's what the Supreme Court said, and this is well-established doctrine, that if the state owes a constitutional obligation and they delegate the government function to a private party who enters into a contract voluntarily to perform that function, then that private party owes that constitutional obligation. It's as straight to the point and short and black and white, and it's been well-established court doctrine for decades now. And so the Fifth Circuit ignored, and what they did is they made this about a vaccination requirement in general, which was not the argument. The argument was that you can't mandate unlicensed medical treatments.
Right.
You're Brian, you brought up sorry to interrupt. I wanted to bring up, to point out what you just said that I think the American people don't really realize. And that was when the US government wanted the nation to be vaccinated with this mRNA, quote, vaccination, they had to recruit other entities to do it. And that's what you're saying, that all these entities who signed the contract with the US government, I want to be a COVID shot provider. They were signing under that federal-wide assurance agreement, and they promised the government, by the way, we won't violate any law or any regulation when we give this to the public. And that was the problem, because they were violating the agreement to not coerce anybody.
And I know Houston Methodist preceded Biden. I assume Shriners preceded Biden as well when they instituted their mandate. And does Biden's mandate, does that affect anything at all?
No, other than it was illegal as well. The CMS, within this legally effective informed consent doctrine, Mary, not only is contractually bound under the federal-wide assurance agreement, which 30,000 entities have contracts promising not to do this, including all U.S. states, but 24 federal agencies also have their own federal-wide assurance contract. The CDC has a federal-wide assurance contract, And within the regulatory framework of 24 federal agencies, they promise not to coerce individuals. And so the executive branch, under, just for the lawyers out there and anybody else who might be listening, under Title 42 of the U.S. Code, Section 289, the executive branch must protect the rights, quote unquote, including when they issue cooperative agreements, which is what the CDC program was, a cooperative agreement, when involving humans with unlicensed medical treatments or related activities. And let me shock you for a moment. And it's because we're dealing with an area of law, the biomedical research industry, and how it impacts the 14th Amendment rights, that you may take 60,000 tort attorneys in America and you may find 5 who understand this information because it's just, there's no money to be made in it. Mm-hmm. But the CDC program itself was a federally funded biomedical research activity. It required all states, hospitals, vaccine manufacturers to monitor and study humans for adverse reactions to the product, obtain what's called their identifiable private information, and then report that research data to various government agencies and the manufacturers. Well, that is a biomedical research activity according to federal law, and that requires your legally effective informed consent. So everyone who took the drug, they volunteered to become a human subject in a federally funded research activity, to be monitored, to publicly disclose their private health information to unknown persons, reasons, and length of time. To this day, they're still being monitored. And that information and that data collected on them can be shared with people around the world through these pharmaceutical companies. And people lack the understanding of the invasion of privacy that we just incurred, that now the judicial branch of government is working overtime to protect and to hide from the American public.
And Brian, you make a really great point that this is biomedical research. These are biomedical products. And so what we're talking about in these cases is not limited to the COVID shots. It can be expanded to any investigational drug, any unlicensed product, any biomedical research. And so these decisions that are ignoring the duty to the American public, they're ignoring the necessity of legally effective informed consent, they are really dangerous to the freedom of Americans in the future, starting now.
Yeah, I mean, it's set a precedent, right? Basically, we can be forced or at least heavily coerced.
Certainly precedent. This is what we're seeing, Mary, across the circuits. Okay, we are having federal circuit decisions, and they are coming down on the side of secrecy, on the side of forcing people without their informed consent. And we need intervention by the federal government, because we've seen, Brian, help me out, the 5th, the 9th, the 10th, the 6th circuits, all in some form or another dismissing actions by citizens regarding this theory, as if to say, nope, you know what? We don't really care about the effective consent. We don't care about the authority argument. We don't care that they broke their promise to the government to not coerce you. There's some reason we're dismissing. And we're having basically the same decisions in different ways across the circuits. And the Supreme Court and the Solicitor General need to weigh in, because what we're noticing is this is an undermining of the judiciary, and the decisions are undermining the executive branch and the power of the Health and Human Services Secretary, because only that office, only that man right now has the authority to alter the way in which experimental drugs are offered to the public. Only he. Therefore, none of these entities had the ability or the authority to change the informed consent rules. That's what we're seeing in the courts right now, is they are ignoring this entirely.
Have any of these lawsuits been heard by the Supreme Court, or are they all getting asked to be considered and denied consideration?
Brian, they have not yet been heard. What we have seen, though, is there have been at least two petitions for certiorari, where you ask the Supreme Court, please look at this case, it was wrong, and those have been denied. And that's
there are 2 cases that I'm consulting on that the Supreme Court just denied. One was Houston Methodist, but I know of others. For example, well, let me just tell you this, Mary, because this will shock you. At the district court level, these cases, none of the defendants, even including Houston Methodist, claimed any authority to mandate these drugs. Houston Methodist defense was basically that, so what if it's true? And I'm paraphrasing here, okay? So what if it's true? You can't sue us. You don't have a cause of action if all these things are true. But nobody claimed any authority to mandate these drugs. So what's happening is that these district court cases are going to the appellate courts for reasons that do not involve investigational mandate authority. Yet the appellate courts, called sua sponte, they're issuing a ruling on an argument that no one disputed under Rule 12b-6, it's called. And the Fifth Circuit, the Ninth Circuit, particularly the Ninth Circuit, just ruled that a governor has the authority to require citizens to use an investigation of a drug as a condition of public benefits. So even in that case, Governor Inslee in Washington State, who was being sued, a case I consulted on, he didn't even argue the right to mandate these drugs. He was basically saying, you can't sue me.
And Brian, that's Curtis, right? You're talking about the Curtis case?
Yeah, Curtis v.
Curtis v. Curtis v. Peace Health. This is one that we need to get before the Supreme Court, because in that case, the Ninth Circuit created a new term that it is not in the record and that neither party came up with. The notion that an investigational product under the EUA statute could be considered clinically identical to another product that had different licensing. Well, no one argued that at all. And they kind of made that up out of whole cloth. And that is one of the bases on which they dismissed the lawsuit. That simply can't stand.
Well, the part that would shock you, Mary, is that the reason these appellate courts are establishing legal precedent that governors, mayors, cities, and hospital CEOs can override the Food, Drug, and Cosmetic Act, because that's what they're ruling, and override the Secretary's authority to mandate unlicensed medical products is because of this. 15 state governors who are Democrat governors created the Governor's Public Health Alliance. And they are establishing laws in their states that literally vitiate the Food, Drug, and Cosmetic Act. And I'm going to give you one of them so that you'll understand the reason behind the judicial corruption. In the state of Illinois, Governor Pritzker issued a law. He literally said that if the FDA does not approve a drug, but the World Health Organization recommends it, then anybody who prescribes this drug, the one that's recommended by WHO, we, the state of Illinois, would not consider it a misbranding felony. So misbranding, of course, is when a person promotes a drug outside of its legal indication as labeled on the product. And so the purpose to this is to create a backdoor authority for the World Health Organization to have power over America's health policies. And these rulings fit in line with that. And so Illinois has no authority to say that misbranding is not a felony. According to the state law, they can, but not the federal government. And that's the purpose. That's why these appellate rulings are hijacking these cases and denying the rights. And so I'll just give you one example of Children's Health Defense. That was a case that came out at least a year ago against Rutgers University. And the court held that the state can apply consequences to anyone not using an EUA product. Well, if you go down to paragraph L of the EUA statute, it says that the secretary has no authority to require anybody to participate in authorized activity, including receiving the product. Well, if the secretary can't mandate the use of a product, neither can states. That's well-known supremacy court doctrine that the court overruled. And shockingly, the Supreme Court in that case, which I did not consult on, also denied cert. And so here's a key point of me saying that. For the first time since 1938, when Congress enacted the Food, Drug, and Cosmetic Act, the Supreme Court of the United States is allowing a lower court ruling that permits states to issue a contradictory legal requirement that conflicts with the Food, Drug, and Cosmetic Act. To my knowledge, that has never been allowed before in the history of the FDCA as applied to Supreme Court doctrine.
And that's exactly what all the jab or job mandates were. They were the entities, the governors, the municipalities, the healthcare providers, presuming and acting as if they had authority greater than the Health and Human Services Director or Secretary. They did not. And yet, as Brian has said, the courts are not even, they're just ignoring that whole authority argument. They are not even engaging with it, as we say. And that is very dangerous because If you don't have authority to do what they did, that's the linchpin that undermines every mandate. And yet they're not going there. They are not addressing that at all.
Well, two things. Okay. When Biden mandated the shots, people sued that got overturned, correct? And how did that get overturned? And then does the PrEP Act play into any of this?
Yes, well, the Biden had multiple mandates. Okay, so let's pretend you're speaking about the specific one with CMS as it relates to hospitals. And part of that was allowed to move forward. Part of it was remanded. However, you need to understand they didn't argue. Nobody argued in that case as it relates to investigational drugs or the drugs classification. They only argued about vaccine mandate authority in general. And under certain circumstances, they allow part of it to move forward. But there was no conversation about the type of drugs that were under mandate, whether the EUA. I don't know why no one made that argument, but they didn't. So the PrEP Act definitely plays in this in two ways. Number one, the PrEP Act has an express preemption clause, which means that Congress physically wrote into the act that no state or political subdivision may issue or establish a legal requirement that conflicts with any requirement under the FDCA. Well, that extends to the FDCA's option to refuse an EUA product. And so we have an express preemption clause that, say, for example, one of the lawsuits I'm consulted on against Colorado Health Authority, in Colorado, where the health agency under a federal water insurance contract mandated everybody use these EUA PrEP Act drugs. They were expressly preempted from engaging in that challenge conduct. Now, these are public employees in the state of Colorado. These are public health care workers. Secondly, and this is an important part for everybody to understand, when you engage or you use a PrEP Act countermeasure, you are quote unquote volunteering to waive your 14th Amendment due process rights to sue another member of society injuring you with a covered countermeasure. That's what they call them listed products that are immunized from liability under the PrEP Act. They're called covered countermeasures. And so the Supreme Court has long said that a citizen, an individual, cannot be required to waive their constitutional guarantees. It cannot be waived under conditions of coercion, intimidation, or force. Those are the literal words used by the Supreme Court. This is well-established doctrine in the Supreme Court, and yet we have the 10th Circuit and the Ninth Circuit effectively, and the Fifth Circuit effectively holding that these entities can mandate individuals to participate in biomedical research activities and products while simultaneously requiring them to waive their due process rights to sue if they're injured by the products. This is one of the greatest abuses of the judicial branch of government in our nation's history, and it undermines the very foundation of our Constitution.
Well, Jennifer, I want to ask.
Yes.
So I read yesterday that Russia has a federal law that none of its citizens can be mandated for any reason whatsoever. But the U.S. does not have that. Is that correct?
Right.
That
I read the same thing. Our American protections are less than Putin's Russia. What do you, how do you go figure?
Right.
But that's true. And what Brian is saying is really, I think most Americans do not realize the protections that they are offered, that there have been given to them by the Food, Drug, and Cosmetic Act, the protection they had against these covered countermeasures, the COVID shots. And, they don't know. It's kind of like Glinda in The Wizard of Oz when she tells Dorothy, "You always had the power, my dear." Well, Americans always had the right to say no without penalty. Again, the statute's very clear. You cannot induce and you can't coerce someone basically into being a lab rat. They have to volunteer for a clinical trial. But the jabber job mandates were absolute coercion. Also, the donuts and pizza. And the free beer or whatever. That was inducement, also unlawful. But that's what we saw across the nation. And that's why Brian and I were both astonished that these are the only cases in the country regarding the biomedical research problem, the lack of informed consent problem, the lack of authority problem that is clearly stated in our laws. Here's the other really annoying thing that's happening in the cases, and that is they are being dismissed because the courts are saying, oh, you don't have a private right of action. The courts are telling these citizens, individual citizens, that yeah, they don't have the ability to sue the government on the protections provided to them in the Food, Drug, and Cosmetic Act.
Why? Well, I
Which
don't
makes
understand.
no, I know, we don't either, because the reason those protections are there and the reason that Senator Ted Kennedy years ago in 1974 was working so hard to make sure these protections would be available to Americans, they are there for the benefit of the American public. They are not there for, who else would they be benefiting if not the recipient of that product, the recipient of that biomedical research, investigational, or experimental drug? And yet the courts are saying, no, 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 you can't sue. Call your congressperson, do something else, but you cannot bring this action to vindicate your own rights. And America was founded on individual liberty, the liberty of the individual to say no or yes. And that's what's being squashed.
So
Well,
has anybody won? Because I feel like I did see something on X. Somebody won $22 million, or there was
You
some
know
mandate case.
what we're seeing, Mary, the success is often in the Title VII religious discrimination actions.
Um,
That is where we are seeing successes. And you'll see the $10.3 million settlement, for example, or the $12 million jury verdict. And again, most of these are religious discrimination where the potential recipient, the person who objected, had sincerely held religious beliefs against taking that COVID injection.
mhm,
And there's a recipe that an employer must follow. And
mhm,
when they don't follow that recipe, that's where your liability comes in. You have to bend over backwards and accommodate the religious conflict of your employee in the workplace. That's where you're seeing the big awards. We have not seen a single victory in this EUA space yet,
mhm,
but that's
mhm.
what we're working towards. Wouldn't you say, Brian?
yeah, and I would just like to piggyback off of what you're saying earlier. To date, Mary, I have been involved in cases where 31 federal judges have reviewed them, and not judicially, by the way. And what's happening is that they are refusing to answer questions of federal preemption. The question is, can a governor mandate these drugs under these legal conditions, under these constitutional requirements? And they cannot. So, for example, the PrEP Act has that express preemption clause that says they can't mandate the use of an EUA drug because that conflicts with the FTC's option to refuse. 31 federal judges absolutely ignore it. They ignored the Food, Drug, and Cosmetic Act, the Supreme Court doctrine that has said since 1938 states can't conflict with the FTCA. So even if you don't have a private right of action under the FDCA, they are supposed to answer the questions of federal preemption of whether or not these entities, these persons, can mandate these drugs under these legal conditions. And once you prove that, particularly in a case like against Mayor Bass of Los Angeles, right? 80 plaintiffs, firefighters, police officers, whatever it might be. Um,
Mhm.
the questions of federal preemption resolves the case in favor of the plaintiffs. You don't even have to get into the muck and mire of everything. But can a political subdivision mandate these type of drugs on these conditions? And the answer is absolutely no. And so think about this: 31 federal judges at district courts and appellate courts and the Supreme Court now, unfortunately, refuse to answer questions of federal preemption, which means they refuse to enforce federal laws for our benefit. And they're waiving our constitutional rights to bodily integrity and our right to due process, forcing us to participate in products where we also have to waive our rights to sue if we're injured by them.
Are
And
there?
that's it. Oh, go ahead.
Well, I was going to say, are there more cases out there that are still alive?
Oh
Oh,
my
for
gosh, I'm
sure.
on
Okay.
Well, yeah,
15 active cases right now.
How many?
and what the case Brian just mentioned, the city of Los Angeles, that's my case. That's McMahon versus the city of Los Angeles. That's Michael McMahon, the first terminated LAPD officer, decorated officer, fired after 14 years of service for basically refusing all of the COVID tyranny in the city. And he founded Roll Call for Freedom and gathered all kinds of other first responders and civilian employees across the city of Los Angeles to push back on the city's mandate. Well, that's been dismissed in the district court because of that Curtis decision, essentially in the Ninth Circuit, basically coming up with all the different reasons about why you can't sue us, or we're going to ignore the preemption, we're going to ignore the authority argument, or we're going to make something up about how the court believes that the original investigational shots were the same as Comirnaty, which was the product that Pfizer told the FDA it was going to produce, and it wanted a marketing license for. And they approved that marketing license, but then never actually put it on the market. But in that moment, there was a bait and switch in the public perception, and suddenly everyone was made to believe that the existing emergency use products on the shelves, all those vials sitting on the shelves, that suddenly they transmogrified into fully approved FDA products, which they did not. But that's exactly what the mandators wanted people to think. Well, that's what the Ninth Circuit is saying. They were basically the same. They were clinically identical. And it's that term that they made up that just cannot stand as the rule, as the reason to dismiss cases.
So is your case still alive? Are you appealing, or is it?
We are appealing. And so, yes, it's still in the process in that we're appealing while we're trying to get Curtis to the Supreme Court, to have the Supreme Court finally look at all of these arguments that Brian and I are raising here. The preemption, the authority, the product itself, the lack of authority by anyone else other than the Health and Human Services Directory. It's very much alive, but it's also a ticking time bomb. There are statutes of limitation, there are filing periods that are running out, and we're kind of we're running up against those.
Is it too late for somebody to start a brand new lawsuit over the mandates?
I'm sad to report that it's possibly too late. We are seeing people's statutes of limitation evaporate by the day because when you look at someone who wants to sue, say, for wrongful termination under a mandate, that's going to generally be, it's going to align with your personal injury statute in your state. California is 2 years, Washington State is 3 years. And these mandates were really happening in 2021, mostly. It's a rare person who was terminated even in 2022. And so most people, if they've been sitting on the fence, sitting on their rights, they would need to talk to somebody really fast to see if there's any kind of claim that's left.
Yeah. And Brian, I couldn't hear you earlier. How many cases are still out there where there's hope that possibly we could get the Supreme Court involved?
Well, currently I'm involved in the same set of facts based on a defendant. And most of the cases that are left are against public and state actors, governors, mayors, political subdivisions. There are 15. Okay. We just filed a brief before the Ninth Circuit Court of Appeals in one of them, East Side Fire and Rescue, which was involved firefighters in Washington State. And that case, federal judge Tina Lynn, I think is her name.
Exactly.
She literally said that Pfizer's drug under EUA is not subject to the informed consent requirements of the EUA. They're just making stuff up. Literally, they're just pulling stuff out of thin air, whatever it takes to get the cases dismissed. Here's the problem, and this is why I have started actively engaging the executive branch. I can't go into it right now, but I have started actively engaging the executive branch to intervene, and that's because there are 3 federal statutes that provide only one person authority to issue authorization conditions for unlicensed drugs, and that is the HHS secretary, currently Kennedy Jr. According to these appellate court rulings, it's not just him now. It's any person who wants to mandate these products. They can mandate them according and establish authorization conditions. And one of the things we've pointed out in the Fifth Circuit, especially against Houston Methodist with Mark Boone, the CEO, is that he effectively engaged in misbranding. You can't, in order for a mandate not to be considered what's called arbitrary and capricious, it must have a legitimate interest stated to it. You must give it a purpose. So if you're going to mandate the use of a drug for the purpose of preventing the coronavirus, then according to Supreme Court precedent since 1938, the drug must be labeled with that legal indication. Mark Boom is not authorized to assign a purpose to an investigational drug. And here's the reason, Mary, and this is what the viewers should really understand, that these unlicensed medical products, you can hold up 5 vials of the Pfizer COVID vaccine, the investigational version, and you could have 5 different formulations. That's because Pfizer is under no requirement to maintain a specific formulation. The reason why is that they're changing the formulations to study its impact on your structure for its safety and efficacy. You are an experimental human subject. Now, it doesn't mean that when an EUA drug is authorized, that it's for a clinical research purpose, okay? What that means, what the EUA, all it means is that we are giving the public the authority to access drugs that are normally restricted from interstate commerce, should they choose to participate in its administration. And you can't mandate someone to participate in an EUA product because an EUA product at its core is an investigational product. And that's why it was put under a special federal program, because we already have a vaccine immunization program nationwide. There was no need to create a special program if it was just a licensed product. So they created a unique program because the CDC itself was under a federal-wide assurance contract with its cooperative agreement to ensure all Americans gave their legally effective informed consent, which they delegated to the states. And here's what you need to know, Mary, not one hospital in Texas could administer the drugs without the authority and approval of the state of Texas, because it was Texas who was responsible for the program. And it's because of the depth of this corruption with this program and who it implicates. I believe it's one of the reasons the Supreme Court will not hear these cases. But the lower courts are taking advantage of that, and they're now amending federal law. So that now we have, think about how crazy this is, Mary. In Houston Methodist has its own institutional review board committee. This committee ensures that none of its staff pressures an individual to use an investigational drug. I know this firsthand. So this committee exists to ensure the legally effective informed consent doctrine is applied faithfully, because a hospital's federal funding is predicated upon it. But now under the Fifth Circuit, who sua sponte ruled on their own version of facts, we now have a drug classification that the executive branch and Congress says you can't mandate, but now the judicial branch of government saying Houston Methodist can mandate not just employees, but contractors, vendors, and volunteers. What is the point of the HHS secretary issuing an EUA if at any time, as the Fifth Circuit said in Shriners, the Fifth Circuit literally said that Shriners' conduct was not unlawful, and then they said it is common practice for hospitals to issue these type of mandates. What type of mandates? Investigational drug mandates, and that was a lie. I'm calling the Fifth Circuit a liar. I'm just telling you right now, they could not produce before the Supreme Court any proof that their state of fact was actually factual. So we have,
in fact, I mean, Brian, that's an excellent point. What is the point if it is going to be overlooked? And in fact, what's the point of the Food, Drug, and Cosmetic Act if it's not going to protect Americans? What is the point?
Well, it sounds like we need a law that you cannot mandate anything, period, right? Is there not a law like that? Just a plain law?
Yeah, it's what we're talking about. It's the FDCA and it's the EUA statute and everything related. It's literally there in black and white. And
it's that simple, and it's still not being. I just thought, well, maybe there's some complicated legality loophole that they're.
As you can tell, this is complicated legality. There's lots of weeds there. You get really into all the subsections of all the codes, but the truth is, it's there. It just needs to be enforced and recognized. You know what you'll see? You'll see states that have enacted their own state law that says, by the way, our citizens will not be subject to biomedical research without their consent, will not be subjected to investigational drugs. But those are going to be red states, and it's rare that we see that type of legislation.
And then even Idaho, they.
Oh, yes.
But the hospitals, from what I understand, the hospitals can still mandate. Is that correct?
Well, here, again, mandate what? Right? You have to look at, is it mandating an FDA approved product? Well, then go ahead. We're not challenging mandating
Right.
FDA-approved products. It's clearly the EUA authority. And in Idaho, with their brilliant medical freedom law, that's fantastic that there will be no mandates of the citizens for any medic to undergo a medical procedure, which
Right.
is great. But you'll also see that the Health Freedom Defense Fund has a case before the Supreme Court, and that's specifically about the COVID shots.
Mm-hmm.
And that is, I mean, they're doing a cert petition. We really are hoping that the court will pick it up. And the issue there is the product itself. Did this shot do what it was sold to be doing, which it didn't? We all know that in August of 2021, even the CDC and Rochelle Walensky, they were admitting that the shot did not prevent infection with or transmission of SARS-CoV-2. And therefore, if you don't prevent infection or transmission of a virus, you're not really having a public health benefit. One man's shot does not affect another man, et cetera.
Mm-hmm.
And if you don't have a public health benefit to stop the spread of disease, as they did way back in 1905 with smallpox and Jacobson v. Massachusetts, then the whole Jacobson decision just doesn't apply anymore.
Mm-hmm.
And that rational basis test that evolved after Jacobson doesn't apply to an employer who is basically telling his employee, I recommend you take this medical treatment because I think it's good for you.
Right.
That needs strict scrutiny. We need to see the employer's compelling interest in why do you have to make Denise in payroll take this medical product treatment if it's not going to stop disease or viral transmission? That is what is at issue in the Health Freedom Defense Fund versus LA Unified School District case that's on the cert petition going up right now. We have so many ways to say no in this country, and they are. It's not. It's a medical treatment only. We have the right to say no. It is not a licensed FDA-approved product. That's the EUA theory. We have the right to say no. And I have a religious objection, and I have the right to say no, and you have to accommodate me. Those are our basic ways to say no, and we're trying to get all of that in front of the Supreme Court right now.
Okay. And then so how can they force it on us? What loopholes are there where they were not allowed to say no?
They
loopholes
did.
was
Yeah, they just did it.
Yeah, the loopholes is that they just did it, and because Mary, like I said in the very beginning, the HHS itself, and I'm not saying HHS under Kennedy, okay? HHS before this administration for the last 40 years, they have concealed the federal-wide assurance program, the legally effective informed consent doctrine, for so long that I've not met a single doctor who knows of it. And so to circle back to what you asked earlier, what are the laws to protect us? Mary, Houston Methodist was under a contract, 2 of them, a federal contract, federal obligations, and 31 federal judges involving entities and defendants like Houston Methodist or political subdivisions. The courts refused to acknowledge the existence of that contract or to compel discovery of them. And yet the Ninth Circuit themselves just ruled on the contract, having never seen it. And let me tell you something, this is the first time the federal courts, these are the first cases in the history of the legally effective informed consent doctrine dating back to 1974 that the federal courts have considered these facts. And so they are presented with the undeniable fact, the undisputable fact, a fact that the defendants themselves do not dispute. And so what they're doing is they're overriding the federal government right now, it's particularly the executive branch. And so I'll just tell you this, that after the National Research Act was passed by Senator Kennedy in 1974 to put an end to all this abuse, and we established a legally effective informed consent doctrine that all hospitals have signed a contract now in all states, the Congress was very, very creative in a very negative way, very corrupt way, to make it hard for a person to just have an outright civil right of action to go sue. And that's what needs to change. So these are 1983 civil rights violations, particularly against the states and the mayors, because it's clear that they're preempted. But I have proposed legislation that would give Americans a civil right of action if any person subjects them, pressures them, coerces them, or punishes them for refusing unlicensed medical treatment, or to be placed under the PrEP Act. We can't require you to take a drug and then say you can't sue anybody if you're injured, and that you must alone burden the physical and financial repercussions of those injuries. And so, as you, Mary, yourself have worked hand in hand with patients that have incurred injury, I have worked on the human heart level of it with police officers and firefighters who have been injured, some of them very severely. They'll never see the end of their life that they were going to have. And, I've been there in those Zoom meetings where they're crying. They don't know how they're going to provide for their children, their family. And their due process rights were waived without notification. They were never informed. They were coerced into it. That violates the Supreme Court doctrine as it relates to a waiver of informed consent when you're waiving your due process rights. And I think it's for that reason that we're seeing the level of corruption. And here's a legal reality, and Jennifer can speak on this, that although the statute of limitations for most Americans under a 1983 civil rights claim or a Title VII claim or a RIFA claim, as I call it, religious freedom claim, has ended, the claims that can be brought back based on fraud, because fraud tolls all, that could get really, really sticky for America as a whole when you could demonstrate that these people engaged in a form of fraud, where they claimed an authority they did not have, and they concealed material facts. For example, Governor Newsom of California, he himself entered into a contract. He volunteered the state of California to ensure that he would offer these products to the public only on the voluntary conditions. And then he turned around and ordered all hospitals in the state to require the medical workers to inject these drugs into their bodies as a condition of access in the medical facility, which effectively terminated their employment if they refused to participate. And he's requiring them, as an act of a state governor, for them to waive their due process rights. He has no constitutional authority. He was contractually prohibited from doing that, and he was expressly preempted under the PrEP Act, and he was preempted under Supreme Court doctrine as it relates to the FDCA. And yet, we have these judges who are dismissing these cases on the wildest of reasons you could possibly imagine. In fact, the judge in the LA case said, well, it doesn't appear that the plaintiffs actually dispute the differences between these drugs, when the entire lawsuit was about that dispute.
Or what about the one, the judge, I believe it was in Oregon, where she decided that a product or the vaccine is really determined by the community. Wasn't that the ruling, Brian?
Yes, she said it is the common belief of the people of the state, not the FDA, CDC, HHS, or the secretary, that determines the drug's safety and efficacy. It is the common belief of the people of the state.
That's just what it, yeah. So it's almost like there was a memo. It's almost like there is a concerted effort that none shall pass, that these district court cases at the lowest trial court level need to be stopped. And if they're stopped, we're going to take the risk. Let's punt them to the appellate court and let's let them deal with it there. And that, I tell you, has stopped a lot of cases of, just like as Brian said, the injuries to people, whether vax injury or whether injured from the mandate, losing careers, losing jobs, losing livelihoods, lifetime medical benefits, etc. The injuries are catastrophic. And largely, I mean, a tiny minority of people affected have been able to sue, and even smaller minority have been able to appeal. And the damage is it's just in the billions. It's practically in the trillions of dollars to American citizens because of this running roughshod over the clear protections we always were supposed to be given. That's the shocking part about all of this. And we're really trying to get some attention on these cases, because if this precedent stands as it exists in the circuits now, that is bad news for the next pandemic and the next shot or injection or treatment that someone decides you need to take in order to keep your job.
Well said. Brian, I assume you have a list of those 31 judges, and I would love to know who they are and distribute that list. Thank y'all so much.
You're welcome.
Uh,
Yeah, and I would say, I would caution, I would just say, I don't ever want to target, I don't ever want to talk about, judges are trying to apply the law. Well, let's always be super generous and say they're trying to do, and we never bring attention to any one particular jurist because that seems so, I don't want to draw attention to the jurists themselves who are dealing with this area. The problem is the pattern that we are seeing in all of the cases. That's just really the issue that's alarming and why we need the federal government to speak up.
have you looked into the judges' political affiliations, or have you dug
You know,
into
it's
that at
interesting.
all?
That's actually people always around election time, people become really interested in the political, but you often don't see that. You can look at who appointed them. Maybe that gives you an idea, but that's not even accurate. That's often kind of hard to find that information.
I will
So
tell you this, that two things I have noticed through observation, and that's my skill set, noticing patterns. Number one, I would say in 80% of the cases I'm involved in, they're always Obama Biden appointed judges. Number two, I can tell you that there has been a lot of malfeasance in the appointment of judges. For example, when a lawsuit was filed in the state of Colorado, it was months before they assigned a judge. In the case in LA County, I think it was, we had a Reagan appointed judge, and then after months for scheduling conflicts, it was replaced with a Biden judge. And I can tell you that when we had an appeal before the Ninth Circuit, that they were supposed to consolidate three cases and have oral arguments for each case on the same day. And month after month after month, they kept canceling the oral arguments. And what they were doing is they were making sure it could get to a panel they agreed with. So the same thing happened in the Fifth Circuit. When we filed in the Fifth Circuit, appellate courts will always consolidate cases involving the same set of facts for just to make sure judicial efficiency. And they refused to consolidate this case. In fact, it was a very big argument, particularly among the defendants, not to consolidate them. And I believe it's because that they found their three-judge panel they wanted. And, you know, we had the auto pen judge that was assigned, Carl Stewart, who's always known to be the problematic judge in the Fifth Circuit, ruling on very liberal issues. And so we are seeing that, in my opinion, I believe there's enough circumstantial evidence to demonstrate that these judges are not acting independently, that they're being assigned a what to do memo by outside sources. That's my personal opinion. And because you can't, you ask any lawyer worth their salt, can a judge just arbitrarily dismiss allegations and override plaintiff's allegations and make arguments or issue rulings on arguments that no one disputed and the defendants didn't even make themselves? And they cannot. It's a huge abusive problem within the federal judiciary, particularly within this realm. And the second thing I will say is that not only in my cases, okay, but let's say Title VII cases where a lot of judges are ruling against them. I've noticed in a number of district courts throughout America that the exact same judges are routinely getting pulled from a lottery to oversee these COVID cases. So you may have a district court, say with 5 or 6 judges, and the same judge gets all the COVID cases. That's not a lottery.
Right.
That's not how that works. They're not being randomly selected.
yes,
And
in the
so,
Ninth Circuit, we have one judge who had at least 4 cases of the same, and they were all dismissed. And then when they're dismissed, they cite each other in this circle of, oh
yes.
yeah, over in that case, oh, actually, I happen to do that. That's what we're seeing. One last point about politics, or sorry, political persuasion and COVID is my observation that it's really interesting. The religion of COVID and the religion of vaccines actually transcends political party. It transcends actual religion. It is itself a religion. So it's really hard to say, oh yes, all conservatives, all Republicans are going to be, pro health freedom or pro informed consent. You really can't say that.
Right.
So it's almost impossible to tie political persuasion to these decisions. But Brian is right. There's patterns there. There are definitely patterns.
Well,
And the other thing that is a lot of the chief justices of these district courts, they themselves issue their own vaccine mandates.
mhm.
Or mask mandates or mandates, you have to follow these protocols. So now they're looking at the fact that they were wrong.
Mhm.
And so we're just running up against a lot of, and listen, because these laws involving the biomedical research industry are so novel, these are the most novel laws in America, in my opinion. I don't blame these judges not knowing these laws up front. No one knew. The legal community didn't know because the federal government for decades concealed these facts. Now, the hospital knew. I know for a fact Houston Methodist knew they could not do it. That's why they didn't dispute it. That's why they didn't claim they could. Everybody, all hospitals have their IRBs, their institutional review boards, but the legal community was not aware of these legal conditions and these contracts that exist. So, but now that they are aware of it, instead of humbling themselves and repenting and ruling judicially, they're trying to overthrow our rights to refuse these type of treatments.
Mm-hmm.
One last little point I want to make. John Bowden, I don't know if you've seen him on X. He's been very active in researching, and he's sued. And it looks like the Supreme Court just shot down his lawsuit. But he posted something yesterday, which I found very interesting, looking at the number of cases, number of lawsuits, federal lawsuits in the country jumped from 295,000 in 2019 to 470,000 the following. It's like a 1 year, 2020 to 2021. And the courts just couldn't keep up. So we saw all these cases get dismissed just because they were flooded with lawsuits.
Yes, and early on in 2021, when people ran into court expecting the rule of law, they got dismissed really quickly because there was too much that was unknown at the time, and the courts were too willing to go, oh, yes, this is what we've always done, and none of this matters. That was unfortunate for those plaintiffs who ran in really expecting the relief that we are now actually seeing. That is the numbers that you just said totally correspond with also the exponential rise in discrimination claims to the EEOC and then to the state discrimination entities like California Civil Rights Department. So you see all these FEHA claims and EEOC that's just gone through the roof because everyone's rights were violated. So it's no surprise that they were overloaded, and frankly, they should have expected it.
Yep. Well, thank y'all so much. This was wonderful, very informative. And
Thank you.
Want y'all to come back when you have some updates on those 15 cases that are hanging on by a thread. Hopefully we can make some traction on that.
Well, thank you, Mary, for having us today.
Thank you, Mary.